Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I wanted to talk about something a little more lighthearted today, and so I picked this case because first, nobody dies in it. The allegation is one of mischief, which is usually, but not always, one of the more minor offenses in the criminal code. And this is also kind of a heartwarming story because it's a story of an injustice prevented. There's also some judicial snark, which I always like. So let's have a look at what's going on. This is the case of the Queen and Phoenix. All right, so this one starts off with introduction. This case arises from a wild and loud house party that disturbed the peace and quiet of the accused neighborhood in the early hours of December 15th, 1990. He pleaded guilty before my brother, Judge Smith, to an information reading as follows. Now, I'm just going to stop here and give a little bit of clarification. When this judge says, my brother, Judge Smith, he doesn't mean that they're literally related, that they're siblings. That's just how you refer to another judge, as my brother, Judge so-and-so, or my sister, Judge so-and-so. So that's all that means. It's just another judge. I know otherwise people might be going, wait a minute, isn't that a conflict? It's not a conflict. There's no relationship here. All right. So the information says that Dale Roger Phoenix, on or about the 15th day of December 1990, at or near the city of Quesnel in the province of British Columbia, did commit mischief in relation to property, to wit, the residence of George R. Young, by willfully interrupting or interfering with the lawful use, enjoyment, or operation of said property located at 945 Broughton Avenue, City of Quesnel, British Columbia, contrary to Section 430 sub 4 of the Criminal Code of Canada. Now you might be saying, wait a minute, they put his address in here? And I would have actually redacted this out, notwithstanding the fact that it's in the public, if not for the fact that this is a 1991 case. That's more than 20 years ago. I doubt any of these people still live there. I don't even know if that house is still there or what the situation is, but this is sort of something that is worth talking about at least a little bit here. It's a bit of a digression, but people tend to be worried or concerned about doxing, and the courts, on the other hand, have a very public information kind of viewpoint. And this is something that may end up being attention in future because you might not want to have your address put out here. Keep in mind, this is the address of the alleged victim of the offense here. So, yeah, we're not going to solve that today, but it is something that we might see courts starting to restrict or limit this. But there's tension there because open courts are an important principle. All right, let's keep going here. And we'll see pretty quickly why I think this case is so interesting. So after hearing the facts alleged by the Crown and defense, Judge Smith refused to accept the guilty plea and directed that a plea of not guilty be entered. So what happened here is that Crown and defense came in and they said, we are pleading guilty to this. Here's the allegations as to what happened. We both agree that these are the facts. And the judge said, no, I'm not doing that. You're having a trial. And the reason why the judge would do that is because the judge thinks that those facts, as they were read to the court, were not enough to make out the crime that was charged, the crime of mischief. And so he says, no, I can't accept this guilty plea because it would be wrong to convict this person of a criminal offense when the facts don't support it. So on it goes to trial, and it keeps going. So as a result, the matter came before me for trial. Once again, counsel for the defense said that his client wanted to enter a plea of guilty. However, I directed that the trial proceed. Since the Crown had called no witnesses, its counsel adopted my suggestion that he inform the court of the facts and seek an admission from counsel for the accused. That was done, and the following facts were agreed to. Now, the reason why the Crown had no witnesses is because defense had said, listen, we're just going to plead guilty. But properly speaking, I mean, the Crown should have made sure they had their witnesses there because they already had an inclination. At least one judge had refused to accept the guilty plea, so they should have realized that maybe a trial is going to happen. And this is actually a moment that kind of looks bad for counsel. And I don't mean to call out these specific people, but it is a rough moment for a lawyer if the judge is going, I don't think I can accept this guilty plea. Because on the defense side, it means maybe you're trying to plead your client guilty to something they haven't actually done. Now, I mean, you might have instructions from your client saying, I want to plead guilty, and you have to follow your client's instructions. And at this point, this case hadn't been decided, so the law on this point was still kind of up in the air. It was not yet settled. The Crown, of course, should also not be seeking a conviction in situations where the accused hasn't done it. The Crown has a legal obligation, an ethical obligation to not seek convictions for people who haven't committed the offense. So, in terms of this aspect of seeking admission from counsel for the accused, I mean, this is a difficult spot that everybody was put in here because they should have had their witnesses. And I mean, otherwise, normally the remedy would be an adjournment, so everybody comes back for another try at this trial. But instead, what they decided is that they were just going to run a trial purely on the agreed facts. So, Crown and defense basically say, we agree that this is what happened. This is a little bit odd, but let's keep going. If there's prejudice to anyone here, it's prejudice to the accused, who is, of course, just trying to plead guilty. He's trying to just get on with sentencing. And the court is going, we're not doing that. We're going to be a real big, we're going to be stick in the muds here and not convict you if we don't think you've done it. All right, so let's have a look at the facts here because we want to know what Mr. Phoenix did. So he resides at 995 Broughton Street, some 75 yards away from 945 Broughton Street, where the complainant, Young, resides with his small children. Small children is kind of an important thing here because it kind of explains a little bit about why Mr. Young might be so upset. At 3:18 a.m., Constable Johnson, in response to a complaint, went to the Phoenix residence. A party was in progress. There was very loud music, and the doors were open. Parties get warm, and so people keep the doors open to cool things off, and that blasts noise out at 3:18 a.m. Unquestionably, this is jerk behavior, and there's noise bylaws that apply to this. There might be the tort, like the civil wrong of nuisance that might apply to this. But the question is this a crime? Is this actually a criminal offense for which this guy should get a criminal record? That's what the court is trying to determine here. So Johnson knocked on the door and Phoenix identified himself. Johnson warned him to keep the noise down. So he just gets a warning, right? But that didn't happen, and at 4:14 a.m., Johnson again went there and again warned Phoenix. The noise did not stop until 5 a.m. Now you think you got young kids. I don't know how young. Like, are these infants? Are they kids who have to go to school the next day? And, if a kid doesn't get to sleep from 3:18 to 5 a.m., you better believe they're going to have a rough day at school. And their teachers are going to have a rough day. The parents everyone is going to have a bad day about this. So from these facts, I infer that Young and his family were unable to sleep and that they were upset enough to call in the help of the police. I also infer that Phoenix was indifferent to the great inconvenience he was causing his neighbors in his hedonistic pursuits. I mentioned some judicial snark. He's kind of dropping a little bit here. He's basically calling Mr. Phoenix a jerk. We could go a little further, but I'll try to keep the expletives out here, but he's not too keen on Mr. Phoenix anyway. And then I love this little paragraph here. This is wonderful for judicial snark, and, the judge is kind of tipping his hand as to his feelings about the world and how it's changing. Since the invention of rock music, which is in scare quotes, and sound amplifiers, such occurrences are, alas, only too common in urban society. The question is whether the conduct of the culprits constitutes the offense of mischief as defined in the criminal code. So even though the judge here is refusing to accept the guilty plea and refusing to go ahead with this, the judge also doesn't like the music, and he doesn't like the accused. So this isn't a situation of like the judge is kind of overly fond of this or biased in favor of the accused. If anything, he's like, I think this guy is a jerk. But just because that's the case doesn't mean he's guilty. So let's keep going. And here's some other wonderful snark from the court. Neither counsel has assisted me by doing any research into the law. Yeah, this is the job of a lawyer, is to do the case law research and bring it to the court. So when he says, neither counsel has assisted me by doing this research, he's kind of expressing some disapproval. And you can imagine why, right? Given that they already know that the court has been not inclined to accept this guilty plea, you'd think that they would come prepared with this kind of thing, right? Here's why the court should accept the guilty plea if they're trying to plead guilty. And that's on both the Crown and the defense. So, and I've been unable to find any case law dealing directly with the issue. I will therefore first analyze the ingredients of the offense of mischief as defined in section 430 sub 1 sub c. So they're breaking down the actual, what does mischief mean? So everyone commits mischief who willfully, and they're jumping to C because this is the subsection that the accused is accused of, obstructs, interrupts, or interferes with the lawful use, enjoyment, or operation of property. And the judge says, since it cannot logically be argued that Phoenix obstructed, interrupted, or interfered with the use or operation of Young's property, I will confine myself to the issues of what willfully and enjoyment mean in this context. So what they mean here is that Mr. Phoenix didn't kick Mr. Young out of his house, or burn the house down, or anything like that that prevents, Mr. Young was still able to live there and to do all the things you normally do in the house except sleep. So they're going to look at what it means to willfully prevent this, and what the enjoyment of property means. That's kind of the key thing here. Because if Mr. Phoenix hasn't interfered with the enjoyment of Mr. Young's property, then he's got to be acquitted. So I infer that Phoenix made the noise, or that he aided and abetted the conduct of those who made it. That makes him a party to the offense that they may have committed by reason of section 21 of the Criminal Code. So it doesn't matter if Mr. Phoenix personally hit play on, at this point it's 1991, it's probably a boombox or something like that. But, if he just, aided or abetted the people who were playing the music, that's enough. So already we're getting past that first hurdle is, did Mr. Phoenix, was he the person who did the thing? So yes, and that establishes identity. So the next question is, did Phoenix act willfully? And so they cite the case of the Queen and Chapman, sitting in British Columbia, held that the use of the word willfully within the context of this offense connotes an evil intention, and that the extended definition of that word in what was then section 371 connoted a deliberate intention to create loss or damage to property, or to its use and enjoyment, or a recklessness as to whether or not loss or damage occurred. In that case, he acquitted a young person who had done no more than push another person's car a few feet away from where it had been parked, causing no damage or inconvenience. The learned trial judge's attention had not been drawn to an earlier decision of a 3-judge panel of the Supreme Court of Nova Scotia, in which they had overruled a decision of a county court judge who had given the same liberal interpretation to section 371 in a case involving an accused who had been acquitted of willfully permitting or causing suffering to an animal. So had the judge been aware of that decision, he might have come to a different conclusion. What the judge here is saying is, okay, we have this one case, but I'm finding that case was wrongly decided because there was this superior court authority from another province that says a different thing. And so the judge may have come to a different conclusion had he been aware of that. The judge is providing reasons for not following a prior case. And this case is actually a case that would have been really beneficial to Mr. Phoenix because, when you're playing music at your house and you're really loud, you're obviously not, the point isn't to bother your neighbors. The point is that you like the loud music. So that would have been great for Mr. Phoenix, but he's rejecting that case. The judge continues, in any event, on the facts, it was open to him to have concluded that apart from the issue of willfulness, no mischief had been committed. That makes his remarks on the issue of willfulness obiter. And what obiter means is that it's not a key part of the decision, and that it is in fact a sort of an aside, a by the way. And obiter is not binding on future courts. It might be something that courts might listen to and consider to be valuable, but it's not binding. And what the judge here is saying in that other decision, pushing somebody's car a few feet to get it out of your way might not be a mischief. It doesn't prevent somebody else from using that property. It doesn't interfere with their enjoyment of it. So that's why he's saying that this is obiter. All right. Although the Crown has not proved to me that Phoenix and his colleagues had intended to interfere with Young's enjoyment of his property, they might not have even known he exists. He's 75 yards down the street, right? I know some of my neighbors who are that far away, but certainly not all of them. So he probably wasn't specifically trying to bother Mr. Young. Their failure or refusal to heed Constable Johnson's warnings raise an inference that they were recklessly unconcerned about the effects of their utterly selfish conduct on Young. So again, you can see that the judge really doesn't like Mr. Phoenix. This is not a situation where he's acquitting him because he thinks that Mr. Phoenix is, wearing a halo and yeah. I conclude that their actions were willful. So this is an important case on the definition of willfulness. It's also an important case on this next issue. Was there an obstruction, interruption, or interference with enjoyment of property? And that's in just quotes, just because they're quoting the statute that he's alleged to have violated. Ordinarily, the word enjoyment denotes the derivation of pleasure. Enjoyment of property may indeed give great pleasure, and the pleasure of occupying a residence would certainly be interfered with if the occupier cannot sleep in it. So that's one possible definition that the court is going to consider, is just, that it actually makes you happy when you're using your property. They said there is, however, a different sense in which enjoyment is used in reference to property. Leases, for example, often contain covenants for quiet enjoyment. Corporations can enjoy the use of land. And I mean, nothing makes a corporation happy, not just because they're, I'm not making a slam on corporations here, but corporations aren't people, right? Corporations don't have emotions. So when you say that a corporation can enjoy the use of land, it's not because it makes the corporation happy. It's just because it can exercise certain rights with respect to the land. That's the point the court is making here. So the Land Transfer Form Act of this province provides for covenants of quiet possession in conveyances and mortgages of land. In Ontario, the Conveyancing and Law of Property Act implies a covenant of quiet enjoyment. The two terms possession and enjoyment are used interchangeably in real property law. This is a lot of research that the judge has been doing, and you saw that he was kind of snarking about how the lawyers didn't. So the judge put some effort into this. And that was probably because he knew that this was going to be on his table, and he already had to have known that a guilty plea had been rejected on this. So quietness in this context is not measured in decibels. And so they note Canadian law of landlord-tenant describes the covenant of quiet enjoyment as an assurance against the consequences of a defective title, including any disturbance founded thereon, and against any substantial interference. So what enjoyment means in this context of land is simply the right to possess it without legal challenge of the title. So if you ever buy land, and one of the things that you will probably be encouraged to invest in, and talk to your lawyer about this, but usually a good idea, is title insurance. And so what that protects you against is, let's say you buy a piece of property and you think it is 50 feet across. And then later it turns out your neighbor says, whoa, your piece of property is actually only 49 feet wide. And this 1 foot of property there is my property. And so this belongs to me. And then you end up in a lawsuit, and title insurance can be of great help there because they can help fight that suit. And if you lose, they might cover the value of that strip of land. All of those things, right? So he's saying that that's what enjoyment means with respect to this, is that you're not going to come and attack the title of the land. All right. If there are two or more different meanings that may be given to a word or phrase in a penal enactment, so a criminal code thing, then the meaning most favorable to a person accused of conduct with penal consequences must be used. So this is a general thing which basically says where a law is unclear in this fashion, there's two perfectly good interpretations. The one that actually benefits the accused person is the one that has to be picked, because the accused person isn't the one who wrote the law. The government is. And so the government basically has to eat the consequences of that unclearness. Now, this interpretation method is largely deprecated now. It's not used very much, because typically instead what the court will do is say, which one do we think is the one that makes the most sense here? And only if there's two meanings and the court doesn't prefer one or the other for some other reason will they actually rely on this. So this doctrine that the court is using here is almost never used anymore. Usually they find every excuse to not use this principle, notwithstanding the fact that I think that this is a really important principle. I think that this is really fundamentally important for people who are trying to relate to the law and trying to understand it, that they be given the benefit of the doubt. All right. So in this case, the meaning to be assigned to enjoyment is possession. To hold otherwise would have the effect of creating an offense punishable by indictment whenever the tort of nuisance is committed, and sometimes even when the conduct falls short of a tort. So basically what the judge is saying here is a tort is a civil wrong, right? It's, negligence is often a tort, where there might not be a crime committed. If you forget to set your parking brake and your car rolls backwards and strikes your neighbor's car, it might not be that you've committed a crime. You didn't intend to do anything, but you still might be on the hook for that tort, that wrong of negligently forgetting to set your parking brake. So basically what he's saying is this would turn a whole bunch of stuff that ordinarily is just civil disputes that people would sue each other over into crimes. And that causes the court to have to intervene more and more into people's lives. So saying, I don't want to do that. That's not how the law should be interpreted here. And so he goes on to give an example. For example, a person burning leaves in a backyard bonfire interferes with the comfort and convenience, and therefore the pleasure of her neighbor in enjoying the occupation of his land. Likewise, a person making construction noises in the erection of a new building. So would a person who plants a tree that eventually blocks the view of his neighbor. None of these things are normally crimes. Burning leaves might be a bylaw violation if it's against the fire code or something like that. If the smoke drifts onto the neighbor's property, it might be a nuisance. But some of these things are not just not crimes, but are things that, in fact, we encourage. If I get out there and I operate the lawnmower, the neighbor might be trying to record a YouTube video and might be going, come on, really? You got to run the mower right now? I'm unhappy about this. But should I be able to should the neighbor be able to have me arrested if that's what's going on? This is what is concerning the court about this proposed interpretation. And, planting a tree that eventually blocks the view of your neighbor. If I plant a tree on my property, it's my property, right? That's also part of my enjoyment. Who ends up being charged with the crime? The person who, whose view is blocked? The person who calls the police on the person who... What a disaster that would be, right? Okay. So if Parliament had intended that all such conduct would constitute an offence, punishable on indictment, it would have said so explicitly. If Parliament had intended enjoyment to mean pleasure, comfort, or convenience rather than possession, then it is not strange that it would have regarded use and operation as incidents of ownership or occupation of land or personal property worthy of protection, but not possession. All right, so conclusion. I conclude that obstruction, interruption, or interference with the enjoyment of property only occurs within the meaning of Section 430 sub 1 sub c of the Criminal Code when it is aimed at the act of or entitlement to possession of that property. Phoenix and his colleagues did not attempt to obstruct, interrupt, or interfere with Young's possession of his property. Therefore, he has not committed an offense under Section 430 of the Criminal Code, and I dismiss the charge against him. Charge dismissed. So everybody involved in this was trying to plead guilty to this, not once, but twice. And Mr. Phoenix is still acquitted. And in my view, this is an injustice avoided. This is a situation where where Mr. Phoenix could well have gotten a criminal record, notwithstanding the fact that he hadn't committed a crime, except if you interpret the law in this fashion that is so expansive and so problematic that it basically means that everything is a crime. And I don't want to see that, and you don't want to see that, right? So what would it look like to actually interrupt with the use, enjoyment, or operation of property in this way? Well, let's say my neighbor is out, he's out and about, and he leaves his door open. And, so I'm not committing a breaking and entering because the door is wide open. I don't have to touch the door. I'm committing a trespass. And note, breaking and entering, you got to check your jurisdiction's laws, right? And it gets really finicky on this. So when I say not committing a breaking and entering, I'm imagining a very specific sort of circumstance here. But I mean, it doesn't matter if there's a breaking and entering at all, because there can be more than one crime, right? But I move into his property, and when he comes home, I have changed the locks, I've barred the doors, I'm sitting there and I've got a baseball bat and I'm telling him that he can't come in. He now can't live in his house anymore because I've moved in. Well, that would be a mischief as well as some other crimes, right? So that is one possibility. Let's say there's somebody who's running a store and I go in there and I block the door to the store. And now nobody else can get into the store and they can't conduct business. That's probably also a mischief there because I'm preventing him from using his property as a store because I'm doing these things. Another example of a mischief is, let's say Mr. Young is unhappy with his court decision. He was really upset about this party. And so he goes over to Mr. Phoenix's story. And this is, again, just a hypothetical. I'm not saying that these people did any of these things, but let's imagine. And slashes Mr. Phoenix's tires. Well, that would be a mischief, right? Because now it's interrupting with his use of the vehicle. So this is a really interesting case. I really like it. And it's kind of a lighthearted story as to what happens here. It's a good outcome, I think, where the judge says, listen, I'm not going to convict this guy if he hasn't done it in law. Anyway, thank you for watching. I hope you enjoyed this story as much as I did. This is one of those cases that I see it and I just kind of want to share it with people because I love the law. I love these kinds of stories you can find in the law, and I hope you guys do as well. So let me know in the comments below what you think of this one. Again, Mr. Phoenix is not sort of being a nice person here. He's not being a good neighbor. But there were other ways to deal with it. Noise bylaws and potentially a lawsuit. It's just not everything that is jerk behavior has to be a crime. That's a big thing. And I think that there's actually sort of a big and important distinction in society between, to a certain extent, our degree of freedom of society is the difference between when jerk behavior starts and then when it becomes a crime. Because if everything that somebody doesn't like is a crime, then we're really not very free to do things unless other people like them. Anyway, that's its own discussion. That's for another day. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, McTain, Mark, Jane Babin, Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., April Crawford, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.